Welcome to Crime in Court. This is the 1996 Menendez brothers trial. We are reading through the transcript. Eric and Lyle Menendez on trial for the homicides of their parents, Kitty and Jose, for the second time. And this was back in the 90s. Their first trial was in 93, second trial in 96, and we are now on the defense's case, part 16. This is firearms examiner Detective Dwight Van Horn, who works for the LA County Sheriff's Department, I believe it is, and he was a witness for the state in the first trial, and now he's a witness, and a very excellent witness, if you ask me, for the defense this time around. So let's get started. Please hit the like button, and we're going to just pick up right where we left off. And this is coming back from their afternoon recess, it appears. And the court says everybody is present and we'll have the jury out, please. Miss Abramson says, I have two more questions, Your Honor. The jury enters the courtroom and the following proceedings were held. The jury says, or the jury is back, says the judge. You may continue your redirect. So this is continued on from the last episode. Ms. Aberson says, thank you, Your Honor. Deputy Van Horn, are you aware of the fact that, or strike that, to your knowledge, was the ballistics evidence in this case submitted to the Sheriff's Crime Lab by the Beverly Hills Police Department back in 1989? Yes, it was. And was there a different firearms examiner who took the first look at this evidence? Yes. And was that Mr. Roberts? Yes. And when you had the evidence resubmitted to you in 1992, that would be not the right. Oh no, that would be the right year. In 1992, were you mindful of the examination that Mr. Roberts had made? Yes. And had Mr. Roberts' examination mainly consisted of identifying the component parts and identifying the size of the shot? Yes. And were your conclusions identical to his on those issues? Mostly. Objection calls for hearsay. Objection sustained. The answer stricken. And in 1989, you had just become a firearms examiner, correct? I had been a firearms examiner for 4 years in 1989. Was Mr. Roberts more senior than you at that time? Jim Roberts I can't remember exactly when they brought the evidence in. Jim started with us in May of 1989, but it came to us from Illinois where he had been a firearms expert in the Illinois State Crime Lab for, I believe, 14 years. So yes, he was senior to me. And by the time the evidence was submitted to you in 1993, you had how many years experience at that point as a firearms examiner? Just shy of 8 years. Now, I just want to go back to one other issue concerning you've indicated that if a number of rounds of number 4 buckshot were fired off in a room, the dimensions of which are approximately 24 feet by 17 feet, you've indicated that there would be some quantity of observable or visible smoke that's produced. Is that correct? Yes, there would be some. And would the density of that smoke be greater if the rounds were all fired off quickly rather than if they were spaced over several minutes, for example? Yes. And if you assume hypothetically the following facts, that the room is dark, there are no direct lights in the room, that the only source of light is a television set that is on, and that the television set is some 17 feet away from, is some 14 to 15 feet away from the decedents in the position that they are in during the shooting, and that the television set, the source of light, is behind the shooters? Is there some visual obstruction that could be caused by the accumulated smoke? Objection. Improper hypothetical calls for speculation, assumes facts, not an evidence. Ms. Aronson says it's a hypothetical. The Court says, well, still, it has to have some basis. Well, it will. The court says, as phrased, it would call for speculation, you'll have to rephrase it. Ms. Abramson says, well, if you assume that Eric Menendez testifies, court says, regardless of proposed testimony, just get to a hypothetical. Well, the hypothetical is that the court says a hypothetical doesn't require testimony from any particular person, just a certain set of facts. You want to proceed? Miss Abramson says the room is dark. The only source of light is a television set. The shooter is standing with the television set behind him and the decedent's in front of him, and there are at least 10 rounds fired off in rapid succession. Would you expect there to be smoke that could impair some vision? Under the circumstances you're describing, I would expect the smoke to be more noticeable than it would in a brightly lit room. I have nothing further. Any recross? Yes. So we get to recross examination with Mr. Khan. Your understanding is that the Beverly Hills Police Department contacted the Sheriff's Department concerning the ballistics in this case prior to your involvement. Is that correct? Yes. And the deputy who was contacted was Rogers. Is that correct? He was a senior criminalist named Jim Roberts. And he was the first criminalist assigned to the case? Yes. And then sometime later, you were contacted by a former prosecutor on this case by the name of Pamela Bazanich. Is that correct? Yes. And she asked you to become involved in the case? I believe I got involved in the case because there was a potential vacation conflict with Jim Roberts on a proposed trial date. And when were you contacted? It would have been prior to receiving the evidence on July 6th, 1993. Okay. So was it your understanding that Roberts, was working on the case since 1989? He says Roberts. And Ms. Abramson says, I'm going to object. Never mind. And because the witness corrected him. And Mr. Khan says, is that correct? The court says the name is Roberts. Mr. Khan says, yes. Is it your understanding that Roberts was on this case since 1989? Well, what do you mean by on the case? The case was brought to his attention back in 1989. Yes. And so he had been consulted on the case between the time period of 89 and 1993. Is that correct? I'm sure he had, yes. Okay. And then in 93, he had a vacation coming up, and that's the reason why you were consulted? I think so. Okay. And that vacation didn't interfere with the testimony at the time that the testimony from the sheriff's department was presented, did it? I really don't recall. In any event, you then became the criminalist assigned to the case. Yes. And he was off the case? At that point, we had two people that had examined the office. That's not unusual when there's a vacation conflict. Uh-huh. And then you've been on the case since 93. Once again, you said been on the case. Uh, Once you prepare your report, sometimes that's all you do until you go to court. So, been on the case doesn't mean like you're investigating or working on the case consistently. So, if that's the way you want to look at it, yes. When did you learn, or how did you learn, that the DA's office was going to be using outside expert testimony in this case instead of the sheriff's department? Object to the form of the question. Rephrase the question. Did you learn at some point that the district attorney's office would no longer be calling you, sir, as an expert, but we would be calling an expert from the outside? Well, no. According to Miss Nahara, about 2 weeks, I'm trying to think when it was. I had vacation in late September, and when I returned from vacation, because I had talked to you previously about getting my transcript from the first trial so I could review it when I came back from vacation, which was the end of September, I contacted Ms. Nahara to tell her that I had a case that I had to go to in Oregon and asked her when I would be testifying, and she told me about 2 to 3 weeks. So they were planning on calling him. Something changed, in the 2 to 3 weeks before trial, and he just outed the prosecution on that. Okay. And then when did you learn that the DA's office was not going to be calling you as an expert, but would be calling Dr. Roger McCarthy? Ms. Abramson says, object to the form of the question. Court says, assumes facts, not an evidence. Mr. Khan says, did you understand at some point that you would not be called as a witness, but that Dr. McCarthy would be called? Object to the form of the question. Overruled. The witness says, I don't know if I ever had a clear understanding of that because Ms. Nahara told me I'd be testifying in a couple of weeks. So I just assumed I was going to be testifying for the prosecution because Ms. Nahara told him so. This is so ridiculous. It's like you're trying to get him on something, and it's like, actually, it was your fault or your office's fault. Mr. Khan says, are you saying that up until this morning you still thought that you would be called by the prosecution? No, I never got a subpoena from the prosecution. I ultimately got a subpoena from the defense. What I'm asking you is, at some point, did you realize you were not going to be called as a witness by the prosecution? When I got one from the defense, I thought there was a good chance I wouldn't be getting one from the prosecution. When did you get that subpoena? I don't have it with me. It's got a date on it. I don't remember. Now, at some point, you learned that the prosecution was going to be called or going to be calling Dr. Roger McCarthy. Is that correct? That's correct. When did you learn that? Once again, I don't have a specific date on that. Can you give us a rough estimate? Maybe the middle of September? We're November 29, so September, October, November, weeks out. And how did you learn that? I really don't recall. You're friends of Dr. Fackler's, aren't you? Yes. And Dr. Fackler has been talking to you about the case, hasn't he? No. As a matter of fact, I talked to Dr. Fackler. As a matter of fact, I called to consult with Dr. Fackler after we had a meeting with the prosecution. And very early into the phone conversation, Dr. Fackler informed me that he was being retained by the defense. And at that point, we had to cease our discussion, and we did so. So you haven't consulted with him in regards to the facts of this case. After I got a defense subpoena, I called him back and we talked. And why is it that you didn't want to consult with him until you received? Why is it that you didn't want to consult with him prior to the time that you received the defense subpoena, but you did want to consult with him after you received the defense subpoena? Because we both felt it would be improper for us to talk being on opposite sides of the case. So, up until that point, he still thought that he was going to be a prosecution witness. And he's friends with Dr. Fackler. So they haven't talked about it. They've been very ethical. This is all very on the up and up, but they're still trying to get him on something, I'm sure. They're going to try. And then once you got a defense subpoena, you felt you were both on the same side, right? I knew that I was being subpoenaed by the defense. Well, you no longer felt that you were on the opposite side. Is that correct? That's correct. So whose side are you on? The side of truth. Love it. He's like, you ain't gonna get me there, buddy. I'm on the truth side. And whose side were you on when you couldn't talk to Dr. Fackler? I was operating under the impression that we wouldn't be talking because it was a conflict of interest. It's just good best practices when you're going to be testifying on opposite sides, not to be discussing the case. And it was only after you learned that we were going to use the services of failure analysis that you began to meet with the defense. Is that correct? Objection, argumentative, overruled. My first meeting was with you to explain my concerns to you. Uh-huh. And after that meeting with me, in which we made it clear to you that we were going to be calling objection Mr. Khan says, in that meeting, did we make it clear to you that we were going to be calling Dr. McCarthy to the stand? I don't remember if you did or not, to tell the truth. And after that meeting, you began to meet with the defense, is that correct? I did not meet with the defense until after receiving a subpoena from the defense and having a phone call requesting a meeting. Uh-huh. And it wasn't until after you learned that you were going to use Dr. Roger McCarthy that we were going to use Dr. Roger McCarthy that you began to review transcripts for the purpose of advising defense counsel as to how they could best go about attacking this prosecution witness. Is that correct? Objection, argumentative, assumes facts, not in evidence. The court says it is argumentative as phrased. He is getting argumentative and sassy. Was it after we informed you that we were going to use the service of Dr. McCarthy that you began meeting with the defense attorneys, or that you began reviewing transcripts at the request of the defense attorneys for the purpose of looking for errors in the testimony of a prosecution witness? Objection, assumes facts not in evidence. Overruled. Would you repeat the question? Yes. Was it after you learned that we were going to be using Dr. McCarthy as a witness that you began reviewing transcripts? Like, are you mad that we chose not to use you so that you could go back to the defense and start reviewing transcripts so that you can point out the errors, to find errors of the prosecution witnesses that you could point out to defense counsel? He says no. After I received a defense subpoena and a request for a meeting with Miss Abramson, I met with her. Simple as that. He's just answering the questions that she's asking. Uh-huh. And then after you met with her once, you had that subpoena in hand. Then you started reviewing transcripts. Is that correct? It was not till probably 2 weeks ago, 2 or 3 weeks ago, that I got Dr. McCarthy's testimony from the trial hearing. And you read all those transcripts, is that correct? No, I read the complete transcript from the pretrial hearing, and I've skimmed over some of the testimony that Dr. McCarthy gave in the trial. Okay. Now, you said in the approximate 250 times that you testified as a witness, as an expert witness, you were called for the defense on only about 5 of those occasions. Is that correct? About, yes. Okay. Now, in those 5 occasions in which you were called as a defense witness, how many of those occasions did you review the transcript of prosecution witnesses so you could advise a criminal defense attorney how to go about attacking that prosecution witness? Objection, Your Honor, assumes facts not in evidence and argumentative, and of course he overrules it and says, you may answer the question. The witness says, none. So this is the first time you've done something like this? Yes. And does the Los Angeles Sheriff's Department customarily review transcripts of the testimony of prosecution witnesses for the purpose of advising defense counsel how to go about attacking the prosecution witnesses? It's my job when I testify in court to be prepared for the testimony. So he needs to know the flaws in the prosecution's testimony so that he can be prepared on the stand for his portion of his testimony. He's not saying he's doing it for the purposes that he's saying, that he's insinuating, he's speculating that he's going through this testimony just to like attack the witness and help the defense. When I mean, a defense witness is going to help the defense. That's what they're supposed to be doing. So it's very deceitful what he's doing to make the jury think that he's doing something nefarious when he's not. And you did in this case, what you did in this case was more than prepare yourself. You prepared a criminal defense attorney in regards to matters that were beyond her competence. Is that correct? Objection, insulting and argumentative. It is argumentative as phrased. Sustained. So now he's insulting the attorney, saying it was beyond her competence. Like, she couldn't do that, so you did it for her. Wow. At least the judge sustained that time. Mr. Khan says, didn't you do more than prepare yourself, sir? You prepared defense counsel in this case. What do you mean by prepared? Didn't you work with the defense to look for problems in the prosecution's case so that the defense attorneys could better attack the prosecution's case? Objection, Your Honor. Assumes facts, not an evidence. Argumentative. Overruled. I reviewed the testimony in the pretrial hearing and some of the testimony in this trial and answered questions as they were posed to me by counsel by Ms. Abramson. And you reviewed that testimony so that when she asked you those questions, you would be able to give her information that she could use to attack the prosecution's case. Isn't that correct? Objection. Argumentative. Overruled. I gave her the answers to the questions she asked me. So he's like, no, I just gave the answers to whatever questions she asked. I was just answering questions, buddy. My question is why you reviewed that testimony. You reviewed it for the purpose of preparing defense counsel to attack the prosecution's case. Isn't that correct? Objection, argumentative, assumes facts, not an evidence, and asked and answered. It is argumentative as you're phrasing it, Mr. Khan. If you rephrase the question, did you review that testimony for the purpose of assisting criminal defense counsel in attacking the prosecution's case? If that's what she ultimately did with it, that's what she ultimately did with it. What you're saying, sir, that you had no idea what she's going to do with that when she said, "Sir, would you review these transcripts?" I knew exactly what she was going to do with it because these are the exact things I told her that I told you about this case. What was she going to do? Use it in this trial to help her clients? I didn't think she was going to use it for just general information. That's a great answer. Yes, she's an attorney. She's going to help her clients. What is so wrong with that? That's like so ridiculous. I cannot believe the jury fell for all this BS, but you know what? Times were different. People didn't understand things, so they still don't understand the law and how attorneys, prosecutors twist stuff like this. So she was going to use it to attack prosecution witnesses, right? I'm going to object to the form of the questions. It is argumentative as phrased, says the court. Move on, sir. Turning to your ballistics evidence or testimony, have you received any material from Mr. Morton concerning ballistics tests that he did in this case? Ms. Abramson gave me a chart that Ms. Abramson says, Your Honor, I'm going to object. This is beyond the scope of redirect. Sustained. Well, you were talking about whether you can look at shotgun patterns and reach conclusions concerning distances based upon shotgun patterns. Is that correct? Objection, Your Honor, beyond the scope of redirect. That was covered in redirect. Overruled. Your question again, sir? Mr. Khan says, yes, you testified today about looking at shotgun spreads and giving estimates in regards to the distances at which such shots were fired. Is that correct? Only when I had the gun that was used and like ammo. Okay. Now, in this case, were you given some material from a Mr. Morton for your review to determine if such conclusions regarding the firing of a shotgun were accurate? Objection beyond the scope of direct. Overruled. I was given a graph that Ms. Abramson gave me, a graph that Mr. Morton had prepared of shotgun shots that he had fired at different distances. And this was for the purpose of advising counsel as to the accuracy of the graph? No, it was just basically in passing. I don't even know what I did with it. I don't think I still have it. Have you advised counsel what you have been telling us today, that you needed the same shotgun to accurately determine? Objection calls for hearsay. Overruled. That's what I've told every prosecutor and defense counsel in this case, and that's what I tell every prosecutor. Okay, thank you. Any further redirect, the court says, and we have some very briefly. All right, so Ms. Abramson asks, Deputy Van Horn, before you got the defense subpoena, you already knew that we had retained Dr. Martin Fackler as an expert in this case, correct? Yes. And before we ever met with you, you also knew, did you not, that we had retained Mr. Charles Morton from the Institute of Forensic Science? Yes. And did you know that Mr. Morton had been retained by the defense counsel years ago in this case? Objection calls for hearsay. Sustained. And do you know Charles Morton to be a qualified ballistics expert, firearms examiner? Yes, I do. And was it your understanding that we subpoenaed you because I needed your advice as to how to attack Roger McCarthy? Could you repeat that? Did you think that I had subpoenaed you to testify because I needed your advice as to how to attack Roger McCarthy? No. Perfect. Question asked and answer received. So you received the transcripts from the pretrial hearing at which I cross-examined Roger McCarthy, correct? So it wasn't even the trial, it was a pretrial hearing that he received transcripts from. Yes. And I did that before we ever talked. Isn't that true? That's correct. Those transcripts were back in early October, correct? I believe so. And it was some months later that I had my first contact with you, correct? It was a time later, yes. In fact, Deputy Van Horn, apart from cross-examining you the last time that you appeared in this case at trial, and prior to you receiving the subpoena, had we ever spoken? Prior to the first trial in 1993? Yeah, no. And except for cross-examining you, we didn't even talk before or during that trial, did we? No, ma'am. And since that time, until we subpoenaed you, we didn't talk? That's correct. And when we did talk, did it appear to you from our conversation that I had pretty much figured out how to attack Roger McCarthy? Objection calls for speculation. Sustained. Nothing further. So she's like, I didn't need your help for Roger McCarthy. I needed you for other things, for Morton and Dr. Fackler, correct? And she wasn't allowed to ask him that because it was speculating, but she got the point out. So she says nothing further. And Mr. Khan has no further questions either. So the court says, okay, thank you, sir. You may step down. The witness says, thank you, Your Honor. And the court is going to call Linhart. Did I have Linhart on here? Hold on. Well, I did not realize that he's over. So, sorry, Dwight, Deputy or Detective Dwight Van Horn is now, he's a, sorry, my concentration is on multiple things right now. Detective Van Horn is off the stand now. I didn't realize that we were done with him so soon. So we're going to go on to Ron Linhart next. And I'll have to change or update our thumbnail to include Ron Linhart as well. So Ms. Abramson calls Ron Linhart, Your Honor. The court says, make sure you don't have any of our exhibits, he says to the witness. He says, yes, I don't, thank you. I'd like to have a couple of these because I don't have any. Ms. Abramson says, I'll see if I can get you some later, Deputy Van Horn. All right, Mr. Linhart. So Ronald Linhart was called as a witness by the defense, was duly sworn in, and testifies as follows. The clerk asks him to raise his hand. He's sworn in, he spells his name, all that good stuff. Now we've got direct examination with Ms. Abramson. Ms. Abramson asks, Mr. Linhart, by whom are you employed, sir? I'm employed by the Los Angeles County Sheriff's Department. And what is your position with the Los Angeles County Sheriff's Department? I'm an assistant director in the Scientific Services Bureau, commonly known as the Crime Lab. And are you a sworn law enforcement officer or are you a civilian employee? I'm a civilian employee. And what is your educational background and training that qualifies you for assistant directorship of the Crime Lab? The assistant director position is in the criminalistics series, so my educational qualifications for this position are those that qualify me for criminalist. That consists of a bachelor's of science degree in chemistry, which I received from the University of California at Riverside in 1972 after being employed by, I'm sorry, in 1971 after being employed by the Sheriff's Department in 1972. I did pursue some courses towards a Master's of Science degree in criminalistics at California State University at Los Angeles. I have received a number of other shooter training courses in various areas of criminalistics at various places for various institutions, some of which have been college credit courses. Will you explain to the jury basically what a criminalist is? A criminalist is one who employs the physical or national science in the evaluation of physical evidence in criminal matters. So you employ physical or national science, like nationally recognized science, in the evaluation of physical evidence in criminal matters. And what is the range of physical evidence that a criminalist can be called upon to evaluate? Oh, my. Virtually anything that is tangible in nature can potentially be physical evidence. The typical broad areas of criminalistics practice are in narcotics analysis, toxicology, that is the identification of chemical substances in body fluids and tissue, trace evidence and analysis, that would be the examination of various types of microscopic evidence or small particles such as hairs, fiber, paints, soils, gas, etc. Serology, that is generally the examination of blood and other body fluids. Crime scene investigations, crime scene reconstructions. One of the specialties in crime scene reconstruction is bloodstain pattern interpretation. Well, that's known as blood spatter interpretation also. That's another way of saying it. Firearms identification, question documents. I don't know if I've exhausted the possibilities, but virtually anything can be physical evidence and subject to our examination. Virtually anything. And have you been with the LA Sheriff's Department Crime Lab since 1972? Not for the entire time. I've been with the County of Los Angeles, employed as a criminalist since 1972, but a little more than 5 years of that time I spent at the Los Angeles County Coroner's Office as a supervising criminalist. And what years was that you were at the coroner's office? I was at the coroner's office between the years of 1982 and 1988. And while you were at the coroner's office, did you become familiar with both personally the work with both personally and I guess professionally of Dr. Golden, the work of Dr. Golden? Yes, I've known Dr. Golden for some years and have worked with him on various cases. Do you respect Dr. Golden and his work? Objection, irrelevant. Overruled. Yes, I've had some successful working relationships with him on various cases and have generally good regard for his abilities as a forensic pathologist. Remember, Dr. Golden is the original pathologist who did the autopsy on Kitty and Jose. He was called in the first trial. He was not called in the second trial by the prosecution, so why not? Instead, they called McCarthy and Dr. Lawrence. Dr. Lawrence was another pathologist who replaced him in this. Basically, a pathologist who looked at all the reports and read everything and looked at the photos and gave his opinion based on another doctor's opinion who was actually in the room and doing the work. Why they wouldn't call him in this second trial, I don't know. It's kind of fishy, right? Ms. Abramson says, and is it typical that a criminalist, particularly a criminalist with the coroner's office, has to work closely with the forensic pathologist? Yes, that was a routine part of the work that I did there. And now, was it, just to stay with this for a moment, was the coroner's office routinely called upon to try to effect shooting reconstructions? This is an area of specialty that I have practiced, not just shooting, but crime scene reconstructions in general. So he's like, this is what he does. Not just shooting, but crime scene reconstruction he does. And during the time that I was there, I did participate in a variety of those. And let me ask you, what areas of criminalistics have you qualified as an expert in over the years? Okay, let me try to take them in order so I don't miss any. I began my career in narcotics analysis and qualified as an expert in that area. I then did blood alcohol analyses, mostly in drunk driving cases, and qualified as an expert in that area. I did some antemortem toxicology, that is, other drugs in the body fluids of living individuals, and I did qualify in that area. I have done some trace evidence analysis, specific areas that I have qualified in being hair analysis, physical matches. What do you mean by physical matches? That's taking different pieces of objects that were once one and seeing if they fit together to demonstrate that they were, in fact, one object. An example would be in a vehicular collision to take pieces of a taillight, one from the vehicle, one from the scene, and see if they match together so we can say that yes, the fragment from the highway was in fact from that particular vehicle. That's an example of a physical match. That would be an example of something that might be useful if there was a hit and run case and you were trying to determine what car might have been involved in causing an injury and there's a piece of car left behind and then you try to match it to the vehicle that has a missing piece. That would be a typical scenario. It can be done in other type cases as well. Okay, let's see. Physical evidence matches. Okay. I was then assigned to serology and spent most of my career, actually, during the time that I was working at the bench as a serologist and qualified a number of times in forensic serology. I participated throughout my career in crime scene investigations and have qualified a number of times in the examination of crime scenes. I also specialized specifically in bloodstain pattern interpretation and crime scene reconstruction and have qualified a number of times in that particular pursuit. More recently, I've qualified on one occasion as an expert in DNA analysis, not in the analysis of DNA, but in the theory of DNA analysis. So, giving the theoretical basis for DNA analysis, well, there were questions that were asked of me in that case that required a theoretical understanding, and I qualified as an expert for that purpose. I promise we're not going to ask any DNA questions here. Now, where, apart from your bachelor's degree, were you trained in the specific areas of criminalistics while employed by the sheriff's department? Yes, I have received on the job training in most of the routine areas, and in many of the more specialized areas, I attended specialized training courses outside the laboratory. For example, in forensic serology, which was my partial analytical specialty, I have attended blood typing classes at the American Red Cross early on, several forensic symposia offered by the Federal Bureau of Investigation at their training academy. In the area of crime scene investigations, I attended a course specifically in that topic area offered by the FBI at their training academy early in my career. In bloodstain pattern interpretation, as far as formal courses are concerned, I attended a week-long college credit course in Elmira, New York. I believe it was in 1979, and a week-long advanced symposium in bloodstain pattern interpretation in 1983. And at that point, we formed a professional organization known as International Association of Blood Stain Pattern Analysts. And I am a charter member of that organization. So he's pretty much an OG on this topic. Does that organization serve as an educational function as well as, I guess, a social or camaraderie one? I think its primary purpose is an educational function and to promote the use of bloodstain pattern interpretation in criminal matters. It's not primarily a social organization. Now, how many, In how many cases have you applied your expertise in either crime scene investigation, crime scene reconstruction, or blood spatter patterns? I have never kept track of the numbers of times that I have testified overall in any specific topic area, but I could provide very imprecise estimates for you if you desire. Well, why not? Okay, I have probably testified on the area of crime scene investigation or reconstruction well in excess of 100 times. And is it your opinion that there are crime scenes in which a scientifically valid reconstruction can be determined? Well, reconstruction of one sort of it or another can often be done, probably in most crime scenes. Complete reconstruction of all events, I would say, can rarely be done. So, yes, crime scene reconstruction can be done and often is possible, but the degree of reconstruction of the crime scene will depend on a whole host of factors, the complexity of the crime scene, and the availability of evidence preserved from which you reconstruct it. And when you use the term complete reconstruction, what do you mean by that? Well, to do a complete reconstruction would be to detail every event that occurred during the course of the commission of the crime. And as I said, that's rarely, if ever, possible. So a complete reconstruction is reconstructing everything at the crime, and very rarely possible, if ever, according to this OG expert on crime scene reconstruction and blood spatter and criminalistic. I need you to either get closer to the mic or bring it closer to you. There's something wrong with my hearing. He says, okay, that's better. Every event that occurred during the commission of the crime? Yes, I said that is it's rarely possible. And does the ability to do that, well, strike that. When you participate in crime scene reconstruction to whatever degree, are you following certain scientific principles? Yes, I am. And when you're talking about the ability to come up with a reconstruction or a complete reconstruction, do you mean the ability to come up with one that is scientifically sound? A reconstruction, to be valid, a valid reconstruction must be scientifically sound. And by that, I mean it must be based upon the foundation of the evidence. The hypothesis reached in the construction must meet the test of the evidence available in the case. So, for instance, you can't say, well, these shots were fired at this distance, but then they were fired when Mrs. Menendez was on the ground, and that would make it that the person would be like standing from the ceiling. So, like, that's not scientifically sound because it doesn't fit the evidence, right? So, that would be one example in this case. And if there isn't sufficient evidence available for whatever reason, is it appropriate, in your opinion, to simply come up with a hypothetical scenario on assumptions about evidence? If assumptions are used in a reconstruction, they must be clearly stated, which was not the case, except he's like, well, I told you on in my testimony, but it's not clearly stated in any of his diagrams, Dr. McCarthy. So, if assumptions are used in a reconstruction, they must be clearly stated so that when evaluating the reliability of the reconstruction, you can evaluate it in a light of the reliability of the assumption. I occasionally will use assumptions in a reconstruction, but I feel obligated to state them clearly in my report. So, assumptions are okay in reconstruction, but you have to identify them, and that's not what happened in this case. At some point, Mr. Linhart, were you asked to take a look at this crime scene for some purpose? Yes, I was. And who asked you to do that? I was asked to evaluate the evidence in the scene by Deputy District Attorney Pamela Bazanich from Trial 1. And what did you do in order to evaluate the evidence in this scene? At the point that I agreed with Ms. Bazanich to attempt to reconstruct events in this scene, I asked for all of the photographs that were available. I asked that I be supplied with the autopsy protocol and crime scene report from the Beverly Hills Police Department and a description of any witness information that she had that might be relevant to the crime scene, and I began to study that information. And when you studied that information, particularly when you studied the photographs, did you use anything to enhance your ability to see the photographs, such as see detail on them? Yes, for certain of the photographs, I received them as 8 by 10 enlargements to enhance some of the details, and in cases where I needed to see them more clearly than I could see in an 8 by 10, I could place the photograph under a stereo microscope, which is a reflected light binocular microscope, which I can control the magnification of low power. I can essentially blow up the photograph to the point where detail is lost in the grain of the film. And have you more recently also received a set of the crime scene photographs on computer disk, CD-ROM disk? Yes, I did. And does the Los Angeles County Sheriff's Crime Lab have computers and computer programs available through which you could use those photographs on CD-ROM? Yes, we do. I was able to view them at the laboratory on the CD-ROM. And did viewing them on CD-ROM add anything, in your opinion, to what you could see when you viewed them previously in enlargements and under the stereo microscope? Actually, no. I used them. They were supplied to me for this more recently at my request simply to refresh my recollection for providing testimony, since part of my foundation for my opinion was from the photographs. But actually, I believe I could see what I needed to see much more clearly from the actual photographs in a stereo microscope than I was able to see on the computer screen with the photographs on the CD-ROM. And did you have a special program on the computer, a Photoshop program that purports to let you clarify images and do that sort of thing? I actually didn't use Photoshop. I'm not sure what that program is. I let our personnel in the laboratory, who are specialized in the use of the computer for that purpose, set it up for me. I don't know the name of the program. So you had another program with which you used to view the photographs? Yes, or the program that was supplied on the CD-ROM. Okay. Prior to the first trial, did you prepare a report concerning some of the opinions that you were able to formulate after viewing the material in this case? Yes, I did prepare a report of opinions that I reached after my review of the evidence. And was that report dated July 15th, 1993? That sounds about right. I have a copy. I could confirm the date if you wish. I don't think anyone is going to dispute it. How long had you been involved with reviewing the evidence in the case before you issued that report? I actually first received the photographs and contact from Ms. Bazanich some considerable time prior to that date. I did not do anything more at that point than a preliminary review and consult with Ms. Bazanich. I didn't begin the work for reconstruction until about June of 1993. And were you able, based on the available evidence and your 20 some odd years experience as a criminalist, to conclude or come to a series of conclusions that comprised a complete reconstruction of this shooting? No, I could not do that. And why could you not do that? Were you unskilled? I do not believe that the limitations in reconstructing this crime scene entirely are primarily based upon limitations in my skills. Well, what do you believe the limitations in reconstructing this crime scene entirely are based upon? It's based upon the complexity of the scene, the large number of various possibilities. Given the circumstances here, that is, two shooters, two decedents, all four of whom were, from the evidence, mobile during at least portions of the time of the shooting. The complexity is based upon the fact that wounds are received in mobile parts of the body, so that it makes it difficult to know what the relative positions of even the limbs are with the torso. It's also based upon the limited availability of evidence from the crime scene. I had only photographs. The photographs were not taken for the specific purpose of crime scene reconstruction or blood stain pattern interpretation. So there were some areas that were not fully visible. So there were a variety of limitations in the evidence and extreme complexity based upon those things I just discussed that, in my opinion, prevented any possibility of a complete reconstruction. So I just want to say we're on like the third, kind of fourth witness. We're still in the middle of I forgot the doctor's name now. We're still in the middle of somebody's testimony of a doctor's testimony as a pathologist. I'm drawing a blank, but he had to be his testimony got cut short because of evidence, I think, and then they had a big discussion, and then he's not being brought back until the next week. So now we've got technically, if you count him, I think that's four witnesses so far that we've had for the defense, and every single one of them so far, maybe or maybe not that doctor, but at least three of them have said this reconstruction is not possible. Doing a reconstruction of this crime isn't possible. That's a reoccurring theme here for the defense, obviously, as we're starting to see. So that's a little bit different of a strategy from the first trial. But again, the first trial they didn't have failure analysis. So really they're putting a lot the defense is putting a lot of their effort to discredit failure analysis, which they should, and they have a lot of evidence to discredit them. So I just wanted to point that out as something that I noticed as we're going along. All right, continuing on. Was it also an inhibiting factor that there was no sampling taken of any of the blood spatter or tissue spatter that was observable at the scene through the photographs? That was a limiting factor that since there were two individuals at least who had bled at that location, it wasn't possible from just the photographs to determine whose blood was in which location. And in many cases, I was unwilling to make assumptions as to whose blood it might be because I considered the reality truly in doubt. In other words, I couldn't make a reasonable guess as to whose blood was in a particular location. Yes, that was another limiting factor because they didn't test it. They never tested the pools of blood that were there. They never tested certain biological material that was near the crime scene, and nor did they identify who it belonged to. So that was another that's another factor, limiting factor, as this witness says. So, did you have a particular methodology, if you will, a mental methodology that you use, Mr. Linhart, when you are attempting to effect a crime scene reconstruction? Yes, I do. And could you explain how you approach the issues of reconstruction, what methodology you use? Yes. Since in reconstructing a crime scene, there's usually a large amount of evidence, there are a large number of conclusions that can be reached, many of which are trivial or not relevant to any issue in this case. It would be a waste of time to try to pursue every single trivial detail, so I like to start with a hypothesis, a question. What is it? What is it that is at issue that we are addressing in this case? I then review the evidence based upon the hypothesis reached from the question or from statements made by witnesses or defendants or victims. I review the hypothesis against the evidence to determine whether the hypothesis is true or not, or possible or not. And there are at least three possibilities. I may either accept the hypothesis, I may reject the hypothesis, or determine the hypothesis is unproven. Would you give us an example just so I understand? So it's a little more concrete. Can you give us an example of what a typical hypothesis would be, perhaps keeping in mind a case where you were able, based on the evidence, to do a reconstruction of the shooting scene? Well, I can give a general example that is fairly simple to explain, that's based upon an actual case that's long been adjudicated, in which there was an individual killed by blunt force trauma, and the suspected killer alleged that he attempted to render aid and that the blood on his shirt sleeve was from cradling the injured person's head in his hand. There was, in fact, blood on his shirt sleeve. So the hypothesis is that the blood on the shirt sleeve was transferred by cradling the injured person's head in the hand in the effort to render aid. I examined bloodstains on the shirt sleeve, determined them to be, in fact, droplets that had been projected through the action of some force, and thus was able to reject the hypothesis that the blood was obtained by cradling the individual's head in the hands, providing an inconsistency in the defendant's account. So that as as form of reconstruction, where did I not reach, this is a really weird sentence, where I did not reach an affirmative conclusion, but denied or rebutted the hypothesis. Well, if I were to ask you to pose, well, let me strike that. I wanted you to continue with what happens when you're trying to do a sequential reconstruction, trying to figure out what happens next and what happened next. What are the steps that you go through? Why can't I say that word right now? In a sequential reconstruction, I will endeavor to find what events could have preceded other events. If there were only two events that I'm trying to sequence and I'm able to determine which preceded the other, then I have successfully reconstructed the sequence. If there are multiple events, more than three, I may be able to sequence two with respect to each other without being able to sequence the third or the fourth. So I will look at the evidence to see which of the events I can sequence relative to each other, and then put the events of those together to see if I can sequence the entire set of events that I'm looking at. Often, I will be left with relative sequencing of only a few events in a reconstruction and be unable to sequence the whole thing. But I have still done a reconstruction in the relative sequence of two or more events. If in your efforts to reconstruct a series of events, such as a shooting, you come to a point where there are two possibilities, two possible interpretations of the evidence, one of which, for example, would support the starting hypothesis and the other would be inconsistent with the starting hypothesis, what would you do? Unless I have some foundation in the evidence for selecting one of those possibilities, I will have to consider the hypothesis of sequence unproven based upon that evidence. So that will terminate my ability to sequence those events until I can find somewhere else in the evidence some reason to prefer one of the possibilities over the other with sufficient certainty to render an opinion as to which is true and more likely. When you're doing this, playing out this hypothesis, and you come to a point where there are two possibilities, is that what you call a branch in the line of trying to recreate the reconstruction or trying to create this reconstruction? Well, one can think of it as a branch, point, or a tree. If one came to, or if we come to a point where there are two possibilities and I cannot select between those with sufficient reliability, then I would have to follow two paths in the sequence of in the subsequent reconstruction. I can't talk. I would have to follow two paths then in the subsequent reconstruction. So he would take the two options that he thinks. So I would end up with more than one reasonably possible alternative. If at another point in the sequence reconstruction I reach another branch point where there are two or more possibilities where I can't select between them, then it branches further. So you can see that the number of possibilities can increase tremendously in a complex sequential reconstruction if there is uncertainty as to whether or as to which several possibilities is the correct one at various places. Well, let's say hypothetically, there are two possible hypotheses. One supports the district attorney's office or the prosecution's theory about a crime scene, and the other one supports the defense theory about a crime scene. I mean, you work for law enforcement. Why don't you just pick the DA's version and ignore all of the inconsistent evidence that points the other way? I select the alternative based upon the foundation in the evidence rather than the more social concerns of who desires which alternative. First of all, do you rely on your own medical expertise when you're dealing with a shooting reconstruction where forensic pathology or the opinions of forensic pathologists are necessary? No. I make it a routine to review in death cases the coroner's autopsy protocol, and will use that as foundation for opinions that I may reach. If I find sufficient detail in the autopsy protocol to answer questions that I think may be answerable, I will contact the autopsy surgeon, the pathologist who conducted the autopsy, and confer with them and ask questions to see if we can further clarify some of the issues. If we can, then I use that as foundation. If they can't answer my questions, then I cannot proceed with that as foundation. Would you ever, Mr. Linhart, if you had a hypothesis in mind and for your hypotheses to be true, a particular wound would have to be post mortem, and you're confronted with a coroner's protocol that calls the wound antemortem, would you simply, on your own, consider it post mortem because it fits your hypothesis and reject the coroner's entry because it's objection argumentative, assumes facts, not an evidence, objection sustained? It's not assuming facts and not an evidence. She's asking him a question. Would you ever reject the coroner's uh, determination or opinion because it doesn't fit your opinion? That's a perfectly legit question. Do you feel that as a criminalist, even with 20 some odd years experience, that you are qualified to make calls on what is antemortem and what is postmortem in wounds? I have some skills in the area that I've developed over the years with observation and some courses of study, but it is certainly not to the level of skills that a forensic pathologist will usually have developed. So I would not take it upon myself to attempt to overturn the pathologist's conclusion. So even though she couldn't ask the question, he still answered it even if it appeared to me to be incorrect. If it appeared to me to be incorrect, I may not use it as foundation, but to reject his opinion, I think would be outside of the area of my expertise. So at least this guy knows where to stay in his lane. So, how many wounds have you observed through photographs or in person over the years? How many bullet wounds of various kinds? Oh my, well, like my testimony, I have made no effort to count, but I'm sure I have observed thousands of bullet wounds, and it has been part of your work. Oh, sorry, this is the next question. And it's been part of your work to be mindful of the appearance of bullet wounds to assist you in your work of crime scene investigation and reconstruction? Yes, that's an area that I have paid attention to. And with all that experience, you still would not feel that it was appropriate for you to overrule the opinion of a pathologist, especially when you hadn't spoken to him? No, I wouldn't consider it appropriate for me to do that because my training has been differently focused and I have not studied medicine nor studied the appearance of wounds to the extent that it is required for a forensic pathologist. Now, with respect to this particular case, you indicated that one of the things that complicated and made complex the scene was the mobility of the persons involved. Do you recall that? Yes, I recall that. And with respect to, does that include the mobility of the decedent? Yes, I believe I stated that specifically. I observed evidence in both cases that suggested that both were mobile at some point during the course of the shooting. If we could turn to that, I would ask you to describe, with respect first to Mrs. Menendez, what evidence you saw that indicated, we'll strike that. When you talk about mobile, are you talking about a full range of mobility? In other words, did you find evidence that suggests that each of the decedents may have been standing up or going from sitting to standing at times after they were shot or while they were shot? That kind of mobile? Yes, that's the kind of mobile I'm talking about. And what evidence did you find that supported your conclusion of that kind of mobility for Mrs. Menendez, if we could begin with her? She had contact transferred blood on the sole of her shoes that was readily visible. By that, I mean blood that was transferred to the shoes by contact of the shoe with the source of wet blood. Simply stated, she stepped in blood. And that would and that was would have required her feet to be in a different position than they were in her final position as shown in the photograph. It would have required her feet to be down on the blood source. Would it also indicate that there was someone shot and someone bleeding, and then she was stepping, placing her foot down on the surface of the blood or bleeding? Stepping, or she could have been down with her feet on the ground but was still moving. Well, what type of evidence did you find that indicated with respect to Mrs. Menendez that she was mobile? Let me ask you this. Did you see evidence that suggested that there was blood patterns showing blood moving down one or both of her legs? That is my recollection, that the pattern of blood that flowed on her legs was indicative of her legs being in an upright position during a portion of the time after the bleeding had started. That makes sense. So the leg wound had to have happened when she was standing. And could you determine, in other words, just to make that simple, she was standing up after she was bleeding? Well, standing or sitting with the legs positioned such that the feet were down so that blood was flowing down the leg. And were you able to form an opinion or conclusion about whether the bleeding that was observed in that pattern was bleeding from a leg wound? I don't know that I would determine that with the number of wounds that she had, that all of the blood that I observed was necessarily from a particular wound. She could have bled from one wound over another and had it drip down. So I don't feel comfortable with identifying in every case exactly which wound the blood came from. Okay. Was there also evidence that you observed that indicated that at some point she probably received a wound while lying down at or near her final position? Yes, I did. And what evidence did you find that supported that conclusion? There was blood spattered near her head in her final resting position that was on the facing edge of the couch, that its configuration was such that it appeared to have a point of origin near the floor, and it was underneath a portion of the couch cushion that was pulled out a bit, which would have shielded the approach of that blood from a higher level. So that meant that the point of origin was near the floor. It was a considerable distance from Mr. Menendez. So it seemed much more likely that it was from her. And at that point, that it was from her, and she was near the floor. Okay. And was that a large quantity of spatter or a rather modest quantity of spatter, as you recall? Those are relative terms, but relative to the distribution of blood about the scene, it was a fairly large quantity. Now, were there other things indicated to you or suggested to you the possibility that Mrs. Menendez may have been standing while she received or after she received any wounds? If I had additional foundation for those opinions, I don't recall it at this point. I did my original review some time ago and then just recently reviewed the photographs sufficient to establish a foundation for my opinions. I didn't make an effort to reestablish the entirety of the foundation, so I don't recall additional foundation. Okay, let's talk then about Mr. Menendez. You indicated that you saw evidence that indicated that he was moving during the time or mobile during the time of the shooting. Can you tell us what that was? Yes, the photographs clearly showed a through and through wound in his left leg, which was described in the autopsy wound as a shotgun wound originating on the inner surface of the leg and exiting on the outer surface of the leg. I observed a number of photographs that showed that leg wound and the area surrounding the leg wound. That kind of wound will necessarily result in some spatter from the exit wound, and I was unable to locate spatter sufficient to account for that, or any spatter that could have been from that, or anywhere in that area of the direction of the travel of that wound if he had been sitting in that location. Therefore, he must have been in a different location or position than he was in the photograph at that time, that the wound was delivered to his leg. Therefore, he must have been able to move. So he was not in the position where he was found on the couch when that leg wound occurred. So therefore, he wasn't dead before he got that leg injury. Would that be a fair statement? Yes, I would conclude from that, since he must have moved to that position that he was in that photograph after he received that wound, that he was alive at the time that he received that wound. That's supported further in the autopsy protocol in the pathologist's statement that that was an antemortem wound, that is, before death. Let me pull up a chart here that has some photographs that I think you may be referring to. This is Exhibit 304, Mr. Linhart. If you look carefully, you will see that each photograph, I think them, I'll remark them in something darker. I'll just go over the markings so that they can be seen easier. Each one has a letter. The witness says, "That's stable." Ms. Abramson says, "Oh, relatively. It's stable enough. It's all right." Or it's all very light. Did you, first of all, recognize that these photographs, A, B, C, D, or A, B, C, F, G, and H, are scene photographs, and in some cases, enlargements of portions of scene photographs from the crime scene? Yes, I recognize them as such back there. When you indicated you saw in the photographs no evidence of any spatter emanating from the leg wound, did these photographs that are up on the board indicate the areas in which you, as a crime scene investigating criminalist, would have expected to find something? Yes. Those photographs and others that I observed showed fairly clearly all of the areas where the spatter would have had to have gone had his leg been in that position at the time that the wound was received. And in doing that, did you also note evidence by way of blood drops in the vicinity of the edge of the couch of the rug that indicated to you that at some point after he was shot, Mr. Menendez was standing up? There are some blood drops near the blood pool that is under the leg wound that are separate and distinct from the blood pool, that are of the size and shape that are characteristic of blood that is dripping straight down, such as could occur from a wound. It seems likely that that would be Mr. Menendez's blood. I couldn't conclude that definitively, uh, were were that his blood, that would indicate that some wound of his was over that area, and no portion of his body in that photograph is over that area. So I would stop short of saying that that was in and of itself evidence that he was standing up. But it is in and of itself evidence that, assuming that it is his blood, that his body was in a different position that appears in that photograph. Well, they never tested the blood, so we don't know that it's his, but we have to assume or speculate. So let me also call your attention, if I can, Mr. Linhart, to some other blood droplets. Did you observe in your review of the photographs what appear to be blood drops in this area here, which is approximately, a foot to a foot and a half away from the couch, the area that I'm circling? Yes, there are some blood drops here, and are they of the same type and size that indicate dripping straight down from a wound? As I recall, there were blood drops in that area that appeared to have dripped straight down. And if hypothetically one were to hypothesize that those drops were Mr. Menendez's blood, does that suggest that his person was a foot to 18 inches away from the couch, or at least part of his person was that far away from the couch in order to leave those blood drops on the rug? Yes, if we take hypothetically that that is in fact Mr. Menendez's blood, then that would indicate that some portion of his body was over that area, because they do appear to have been drops that dripped straight down. Did you, when you were examining this crime scene from a reconstruction standpoint, reach a conclusion as to whether or not this was a crime crime scene where a complete reconstruction could be obtained. Yes, I did reach a conclusion on that. And what was that conclusion? From the evidence available in this particular case, I could not reconstruct the events nor the sequence of events accurately. And that was simply given the complexity and what was available by way of evidence. Yes, it's based upon both facts. With a case of this complexity, I seriously doubt that any amount of evidence that would have been available after the fact would be permitted a complete reconstruction, but with the evidence that was available, it was a certain possibility, or it was certainly impossible. And you're aware that the evidence that was available to you is the same evidence that's available to anybody else who comes upon this after the fact to try and reconstruct. Objection, argumentative, rephrase the question. Do you know of any evidence that was not made available to you that has been made available to anybody else that would assist in a reconstruction of this crime scene? The only items of evidence that I know of that others may have reviewed from the crime scene directly that I have not are the x-rays, and I know of the existence of those x-rays and would have requested them had it appeared to me that there was any possibility of them contributing further to my conclusions. And do you think that the x-rays solved the problem of the complexity and lack of evidence here? No, I cannot see how they could do that. I had a reasonable description of the place of the place of the wounds from the autopsy protocol already, and the nature of the weapons used. Sorry, I understood the X-rays were described to me that they demonstrated the placement of the pellets within the bodies, and I didn't see how I could use that further. So the placement of pellets inside the bodies wasn't something, I mean, the specific place wasn't something that you felt would allow you to reconstruct this shooting sequence. Is that correct? It would have contributed nothing further to the conclusions that I was able to reach. Now, are you familiar with the testimony and the opinions of Roger McCarthy of failure analysis? I was provided with a written report that was produced by him and have read portions of transcripts of testimony he was offered in this case. And based on reading those materials, do you have an opinion concerning the methodology that was utilized by Dr. McCarthy in coming up with of what he is calling a reconstruction? Objection, no foundation, calls for speculation. Overruled. Yes, I do, says the witness. Would you share with us that opinion? It's my opinion that many of the conclusions that were reached in his written report and in the portions of testimony that I read were reached without adequate foundation, and in some cases were reached by ignoring certain portions of the evidence that were available. Well, that doesn't sound good for the state. But again, it didn't work for the jury, unfortunately. And do you have in mind what portions, we'll strike that, are those portions of the evidence, those that were ignored, those that are, in your opinion, might have led to contrary conclusions than the ones that Dr. McCarthy expressed? In some cases, yes. And do you have in mind what those portions of the evidence, shall we say, inconvenient portions of the evidence are that are being ignored? Objection, argumentative, sustained as being argumentative. Can you tell us what these portions are that you believe he ignored that might have led to opposite conclusions? Within the realm of evidence that I specifically examined and those areas in which I have expertise, one specifically was the position of Mr. Menendez at the time he received the leg wound and the ordering of the leg wounds relative to the head wound. And you've pretty much testified here as to what your opinions are concerning those things. Is it because of the basis of your opinion that you find that his opinion in those areas are wrong? That's correct. Now, did you take note when you were reviewing? We'll get back to that in a moment. Did you take note when you were reviewing the photographs of a piece of what appeared to be human tissue that was on the couch cushion immediately adjacent to the body of Mr. Menendez in the position that body was in when it was found by the police? Yes, I did observe in various of the photographs a piece of tissue on the couch section adjacent to Mr. Menendez. And did you recognize what type of tissue that was? Yes, I did. And what type of tissue did you recognize it to be? That appeared to me to be brain tissue. And did the existence of that piece of brain tissue on the couch, did that constitute another piece of evidence that, in your opinion, Dr. McCarthy ignored in reaching his conclusions? As I understand the conclusions he reached in the report regarding the position of Mrs. Menendez at the time that Mr. Menendez received the head wound, that brain tissue and other evidence on that area of the couch would seem to contradict the conclusion that she was seated next to him at the time that he received the head wound. I mean, how much clearer can you be to the jury? And they still didn't get it. All right, so now, while my recollection of the report is not that he specifically stated that she was seated there at the time, it was stated that head wound was received immediately following the preceding wound, at which time she was on the couch. So if immediately means as I would usually take immediately, then I would disagree with that. Well, let me call your attention to this. This is an FAA illustration, failure analysis illustration, that's supposed to show positions of the decedents at the time when the head wound was received. Objection misstates the testimony of Dr. McCarthy's concerning that illustration. The court says without characterizing the testimony, you can just show it to the witness. Just so you can orient yourself, the figure here is supposed to represent Mr. Menendez, the figure to the right is supposed to be Mrs. Menendez, and this is supposed to capture the moment at which, as you can see, the head wound is administered. Objection misstates the testimony of Dr. McCarthy explaining the illustration. The court says the illustration speaks for itself. The witness, I assume, has seen it before. Ms. Abramson says, have you seen it before? I don't recall having seen that particular illustration before. Suck it, Judge. I did not review the illustrations that were present on the CD-ROM. I just looked at the photos to refresh my recollection. Well, why don't you rephrase the question, says the court. You can ask him to assume certain facts or certain things. Yes, I want you to assume that this illustration, that the figure on the far right of the couch is supposed to represent Mr. Menendez at the time that he received the head wound, and the figure next to him is supposed to represent Mrs. Menendez, okay? All right. Now, does your opinion about the reference of the brain tissue on the couch contradict this illustration? Yes, if the green line purports to represent the shotgun wound to Mr. Menendez's head, then that would be an inaccurate characterization of Mrs. Menendez's position. Thank you. Before we finish up for the day, let me ask you this. All the time of the first trial, did you come here to Van Nuys to the district attorney's office and have a joint meeting with Mrs. Bazanich, the prosecutor, myself, and Mr. Burt, who was at the time one of the lawyers for one of the defendants in this case? That would be Lyle. I had such a meeting. I recall your presence and Ms. Bazanich. I don't recall who else was present. Okay. He made big impressions on you. In any event, about Mr. Burt, in any event, did you discuss at that time, among other things, or most specifically, this information about the leg wound to Mr. Menendez and how, in your opinion, he could not have been in that position at the time he received that leg wound? I recall discussing that with you and Ms. Bazanich at the time. And after that day, when he had that joint discussion, when was the next time that you and I had any contact whatsoever? You contacted me a day or two after opening statements were made in this case to advise me that I was a potential witness for the defense. And was there a meeting arranged at the crime lab? There was a few days or weeks after that. I don't remember the date. And was that meeting at the crime lab the first meeting that you and I both participated in since the meeting that we had participated in here with Ms. Bazanich 2 years ago? Yes, it was. I believe that was the next occasion that I saw you in person. And who else was present in that meeting? Well, there were a lot of people. Let me make it easier. Mr. Khan and Ms. Nahira there? Yes, both were there. Was another member of the district attorney's office also there? I believe so. A Mr. Mahia? Mahia? Juan Mahia? Was myself and Mr. Gessler present? Yes, both of you. And was your captain present? Yes, Captain Soderberg was present. And anybody else that you can remember? I believe Walter Christula or something like that was there, if my recollection serves. And Mr. Christula is a district public offender or deputy public defender? Yes, he is. And he is also a former employee of the LA County Sheriff's Crime Lab. Yes, Mr. Christula was employed formerly by the LA County Sheriff's Crime Lab. And at that meeting, did we discuss the report that you had prepared 2 years ago and some of your opinions concerning the crime scene? Yes, we did. The court says we'll resume tomorrow at 8:30. Don't discuss the matter with anyone. Don't form any final opinions about it. We'll ask that you return tomorrow at 8:30. And the proceedings were adjourned until 8:30 the following day. And we're done. So nothing after that. So that will conclude us for part 16, and we'll continue on with Ron Linhart's testimony going further tomorrow. So thank you guys so much for watching. Please don't forget to hit the like, subscribe, and I'll see you guys in the next one. Take care. Bye now.